from the Attorney General, if anything, confirms that the focus that we have brought to bear on this is reasonable. Under no circumstance, no one should be under any delusion that the Attorney General's guidelines set the perimeters for federal enforcement. Federal enforcement could be even more widespread than that. And so I think what prompted the discussion was whether or not the Attorney General's pronouncement, whether or not his reference to what the then candidate Obama, now President Obama, may have said during the campaign, would really be a sea change in the approach of federal law enforcement vis-a-vis the enforcement of these laws. And I'm saying no, they're not. But that there should be some guidance to people who are out there in this marketplace, basically, as entrepreneurs, as purveyors, whatever, as to what the lines are. They may be not bright lines, they may be blurry lines, but what the lines are for operating in a safe mode. If you're in the business of selling marijuana for profit, you are in harm's way. If you are in the enterprise of providing marijuana to persons who have claimed legitimate basis for use, there are things you can do, according to the guidelines, to ensure that you will be fully compliant with 215, as the Attorney General of the state sees it. Those criteria seem to be, to me, they seem to be fairly reasonable. As to the review of past cases that may be pending and so on, I think this is true. I mean, we're all lawyers or law students here. It should be obvious to you that negotiations that are carried on between either the defendant and the government, or the defendant's legal representative and the government. So if anyone has some legitimate claim or complaint that somehow or another there's been a change, or should be a change, or is going to be a change that would affect their pending case, then those lawyers certainly are skilled enough to know how to get redress for that. One of the advantages, as I said, of being around forever on this subject is that you build up a lot of storehouse of information. And the Schaefer Commission, which Delph made reference to here in the beginning as a commission report that somehow or another first established not the efficacy, the innocence of marijuana, and recommended that it not be criminalized, or that it be decriminalized. It's just not so. I'm quoting here from the hearings before the Committee of the Judiciary, the United States Senate, in June of 1974, where the same argument was made. And one of the witnesses testifying was a member of the Schaefer Commission, Dr. Henry Brill, who said, and I'm not going to read this whole excerpt, but he said, "I'm concerned about the misinterpretations which have developed with respect to the marijuana report of that commission, the Schaefer Commission. These misinterpretations result from reading the reassuring passages in the report and ignoring the final conclusions and recommendations in the passages in the report on which they were based. As a result, it has been claimed that the Commission's report was intended to give marijuana a clean bill of health, and as a covert or indirect support for legalization of this drug in the near future, or as a step in that direction. Nothing could be further from the truth. From my knowledge of the proceedings of the Commission, I can reaffirm that the report and the subsequent statements by the Commission meant exactly what they said, namely, this drug should not be legalized, that control measures for trafficking in the drug were necessary and should be continued, and that use of this drug should be discouraged because of its potential hazards." That's the Schaefer Commission in 1970. So, again, as I say, local law enforcement may have its prejudices about enforcement. It may even have its cynical view of Prop 215. I share that cynical view. I make no bones about that. I've said that all along. I think that the clear language of the proposition itself, which you did correctly quote, Joe, that said, in conclusion, or any other illness for which marijuana provides itself, which means you self-medicate. You basically are the person that makes the decision whether or not you think that it has any efficaciousness with respect to you. Then you go to a doctor, and this is where there is, again, more cynicism. Doctors just charging for the issuance of a prescription or a letter of recommendation without the full examination that's called for in the guidelines themselves, and we know that this is true, not just in this district but elsewhere in California. The slipping and sliding around what is required in order to sort of provide to some another pretext for drug use. How many of the doctors who are actually prescribing or providing these letters are taking a history and conducting a good faith examination of the patient, developing a treatment plan with objectives, providing informed consent including discussion of side effects, periodically reviewing the treatment's efficacy, consulting as necessary, keeping proper records supporting the decision to recommend the use of medical marijuana. In some instances, I can tell you, it's phoned in. And the prescription or the letter of recommendation is provided by fax with no contact between the patient and the physician. So let's not be too quick here to say that the system as it's working and as it's operating is operating perfectly, or that all of the necessary traps and traces are being respected to ensure that only those people who are arguably entitled to have marijuana dispensed to them because they are patients are the ones who are receiving it. And remember this, again, what I said before in terms of the synthesis. When marijuana was first came onto the scene, nobody argued that it had any medical efficaciousness. Nobody suggested that it was going to be a treatment for any kind of illnesses. It was only as a part of the sort of developing culture of legalization of marijuana for general use that there were these suggested carve-outs for treatment with virtually no scientific or medical support. So, we're a long way from kind of a perfect world, but in this environment, I think that the extent to which the federal government is attempting in good faith here to prioritize and to focus on the commercial entrepreneurs, that's the most that you should expect.
Well, we agree on this, that we're far from a perfect world. How to fix it, we may not agree on. Our organization and most medical marijuana advocates agree that it's not a perfect system. There are flaws in the system, and that's why we have consistently been pushing for greater regulation. The Attorney General guidelines are something we've been asking for years, and we helped the Attorney General draft those guidelines. So we think greater regulation is a good thing. The problem is when you have federal interference, it makes it more difficult to be able to regulate yourselves. All we've been saying in the state of California is that we can regulate ourselves. We don't need the feds coming in here and regulating us. That makes the system even less perfect. There may be doctors who just phone it in. And the California Medical Board should investigate that and regulate that. But the fact that there may be a few flaws in the system, the fact that there may be some patients who get this who maybe shouldn't be getting this medicine, it's like OxyContin. It doesn't mean you just throw out the baby with the bathwater. It doesn't mean you deprive AIDS patients of this medicine that helps them eat, or cancer patients with this medicine that helps them eat. Yes, there are flaws in the system, but that's not a good enough reason to go after it.
Well, the Attorney General has suggested here that there are certain indicia of unlawful operation. I'd like to know, what is the trade group? And I assume that you consider yourselves to be a trade group.
No.
All right. What is the organization then of the cannabis clubs or the dispensaries in the state and so on? What are they doing? What are they undertaking to regulate themselves, to identify what may be some of the indicia of unlawfulness, so that before it gets to the case of whether or not there's a prosecution, the industry itself is ensuring that only those people who are scrupulously adhering to the guidelines stay in business. Because the indicia are very clear. Any dispensary, storefront dispensary, that has excessive amounts of marijuana, excessive amounts of cash, fails to follow local and state laws applicable to similar businesses, such as maintenance of any required licenses and payment for required taxes, including sales tax, has weapons on the premises, other illicit drugs, purchases from or sells or distributes to non-members, or distributes outside California. Those are all indicia of unlawful behavior. Those are the kinds of things that would clearly indicate, both to a state law enforcement officer as well as to a federal law enforcement officer, that what we're looking at is a commercial